This is a lecture from Open Tuition. To benefit from the lecture, you should download the free lecture notes from opentuition.com.
Right, we're still on partnership, so this is the second lecture on partnership law, and we're looking now at dissolutions and the grounds for dissolving a partnership. There are some automatic grounds, and there are some where the court will say, we're directing that the partnership shall be dissolved. And you have to satisfy the court that there is good reason for the court to become involved and for the court to order the dissolution of that partnership. So here we go. Death. Well, clearly, if you and I are in partnership and I die, then the partnership finishes. The partnership, you see, doesn't have a separate legal identity. It's not like a company. It's not like a company at all. So it's just two or more individuals carrying on business in common. And when one individual dies, then that's the end of it. It's like a marriage. When one person dies, when the wife or the husband dies, that's the end of the marriage. So death of a partner brings about the end of the partnership. No question. No question. It's not, but what if, or shall we agree differently? No, the death of a partner brings about the end of the partnership. Automatic. Insolvency, where one partner declares themselves to be insolvent, bankrupt. I'm bankrupt. Again, we're not like a limited company where the liability of the partners involved, where the liability is limited in a limited company, where the liability of members in a company is limited. The liability of partners is unlimited. I said this in the last lecture, if you remember, that if I cause great loss to the firm and now I'm bankrupt, well, the firm is dissolved, but you are liable for all the assets or all the debts that I have created for the partnership. So insolvency of a partner, you cannot have a bankrupt partner because it's unfair on the creditors of the firm. All the partners shall be unlimitedly liable, but if that's okay, but if I have no assets, it makes no difference to me. So insolvency of a partner brings about the end of the firm. Sending notice. Remember in the last lecture I mentioned partnership at will. If there's no time period fixed for the partnership, then it can be dissolved at any time by any partner sending notice. It's a partnership at will. And you write to the other two of us and say, notice is hereby given. The partnership shall be dissolved at the end of this month. That's it, automatic. Share pledged to settle partners' private debts. I live in an enormous house. I live in a huge house. There's no way that I'm going to spend my life cleaning my windows. There's just too many. But apart from the house, I don't have any other asset except my share of profits from the partnership. I have no other income apart from my share of profits. So when the window cleaner came to me 3 months ago and said, I've done your windows, you've not paid me now for 2 months. That's now 3 months with this month's windows. And that's £5,000 that you owe me. I said, it can't be that much. Besides that, I don't have that sort of money. I certainly don't have it, not got my checkbook with me. And listen, I tell you what I'll do. I'll allocate to you my share of profits from the partnership so that when the profit share is announced, you will get my profits, you will get my share. If I charge my share of profits in order to settle my private debts, that's the equivalent of me declaring myself insolvent, bankrupt. And so in that situation, the partnership is dissolved. A joint venture is a partnership for a limited period or venture, adventure. It's a partnership of a limited nature for some specific venture or adventure. And so the end of the adventure, at the end of the venture, do you remember in the last lecture, you and I operated a stall selling ACCA products and promoting the idea of ACCA. Well, at the end of that 2-week exhibition, careers exhibition, the object of the venture is over. Automatic dissolution. You don't want any more relationship with me, and I don't want one with you. So that's it. Object of the venture is over. Automatic dissolution. I mentioned also in the previous lecture the possibility that PricewaterhouseCoopers would set up a partnership for a 30-year period. But at the end of that period, the partnership will close. It's not the lapse of time. When a partnership is created for a specified period, on the expiration of that time period, partnership finished. When one partner is unable to carry out their, I'm going to sneeze again. Where one partner is unable to fulfill their duties, they carry out their obligations. I used to use as an example. No, I'll not go there. I'll not go there. You and I are in partnership as chauffeurs. We've established a chauffeuring business. You get banned from driving. You can no longer chauffeur. Where one partner becomes incapable or is not able to perform their obligations under the partnership agreement. Well, you may say, look, I'm still alive. I'm not insane. I'm not bankrupt. The object of the venture is not ended. There's still people want chauffeuring. So I said, yeah, but you can't do your job. You can't do your job. You say, yes, but I'm still alive. And I'm not bankrupt, and it's not automatic dissolution. I'll go to court. If you're arguing, I'll go to court and get the court to dissolve the firm. Possibility about the court. The court in the UK, court in England, has got phenomenal powers. They can do anything the court wants. They can make any such order as the court thinks fit. When we come to company law, you see that the court can get involved and can change the constitution of a company if it's just and equitable. If the court thinks it's the right thing to do, they'll just interfere within a company's affairs and then say, there you are, now go on, carry on. If the court thinks it's the right thing to do, to get rid of a partner, to dissolve the firm, they can do so. Termination by the court under the principles of just and equitable. Insanity. How do you prove insanity? Death. It's easy, isn't it? Death, you get a doctor to come and certify the death. Or you kick and kick and kick and kick and set fire and burn, and if they don't move, then they're dead. But no, you do it through medical opinion. But how do you establish insanity? How do you prove to anyone that a person is insane? Well, I think you're insane. We'll do it the other way. You think I'm insane. No, I'm not. I'm not. Just because I shout a bit, I'm not insane. So you go to court and say, will you dissolve the partnership because I think Mike's insane? I'm not. The court says, be quiet. Why? Are you insane, says the court? No! The court may grant your request and order the dissolution of the partnership. It's only able to carry on at a loss. Remember, a definition of a partnership, you do remember the definition of a partnership. It's the relationship that subsists between two or more people carrying on business in common with a view to profit. But just recently, this last 15 years, we've sustained loss after loss after loss after loss. And I say, look, we can't continue. We're just making loss after loss after loss. Yes, we can. You say, yes, we can. This year's going to be different. No, we can't. We're running out of raw materials. We were in the business of selling painted dinosaur eggs. But we can't source any more dinosaur eggs. All we could is expenses. We can't get any more raw materials. Yes, we can. Yes, I know somebody. I met somebody on the market last week. No, we can't. It's going to be a loss maker. So I go to court. Will you dissolve the partnership for me? Will you grant a dissolution order on the basis that We can only continue at a loss. Yes, said the court, you're right. Naughty conduct, calculated to affect the carrying on of the firm prejudicially. I'll give you an example here. I'll give you two examples. There was a partner in one of the big four in the UK not long ago, well, 10, 15 years ago. Oh, more than that, 20 years ago. And he lived in Brighton and commuted to London every day. And one day he was late at Brighton. He was late to catch the train. He got the train, but he couldn't buy a ticket. And when he got to whichever station it is that Brighton train goes to, there's a ticket collector there. And he waited till everyone had gone through. And then he said to the collector, he said, I'm awfully sorry, but I didn't have time to buy a ticket this morning. So can I pay the excess fare? Can I buy a ticket now? And the ticket collector said, yes, where did you come from? And he said, Stratford, which is just one stop down the line. He thought, why should I pay from Brighton? This man doesn't know I've come from Brighton. So he said Stratford, which is just one tube stop down the line. So he paid, and he realised that if he did this on a regular basis, he could save himself a lot of money. This is a partner in one of the big four in London, making mega bucks. If I do this on a regular basis, I can save myself a lot of money. So he did, once a week, sometimes twice a week. And one day he was saying, I'm sorry, I just got on my phone, I just managed to catch the train, didn't get time to buy a ticket. The ticket collector said, where did you come from? He said, Stratford. And he felt a tap on his shoulder. Excuse me, sir, would you come with us? It was the railway police. And they'd followed him. They were suspicious of this man who kept missing the train or kept catching the train without time to buy a ticket. And they'd followed him one night and sat on the station at Brighton. And they were there at 6:30 when this man appeared. The train came in at 7:15, and he caught the 7:15 train. Went into London. He said, I didn't have time to buy a ticket, and that's when they caught him. Sir, we followed you. Sir, we've been there all night. Sir, you've been cheating the railway. Sir, we're going to fine you and take you to court. Naughty conduct, calculated to affect the carrying on of the partnership prejudicially. What do you think hit the fan when the news came out that this partner had been cheating the railway company for effectively for nothing, given the salary or the share of profits that this man was making? That was one. I'll give you another one, and a little bit more light-hearted, about the accountant in Leeds. The accountant in Leeds who had a liking for collecting women's underwear. And I don't mean going to Victoria's Secret shops and buying it. He would patrol the streets of Leeds in the evening, at night, and during the summer, where people had had a wash and they put the washing out on the washing line. And he would go through the estates in Leeds, and if he saw some ladies' underwear on the washing line, he would hop over into their garden, take this lady's underwear, rush back and disappear. And he was caught. This was an accountant. He was caught and arrested, and the police got a warrant to search his home, and they found 734 pairs of women's underwear. He was a partner. Calculated to affect the carrying on of the firm prejudicially. Can you imagine the headlines in the local newspaper? Can you imagine the reaction of this man's clients through the firm? Can you imagine the joy of other partners in other firms in the same town? Say, whoa, look what's happened to XYZ partnership. X has been arrested and fined, penalised, lost his accountancy qualification, calculated to affect the carrying on of the partnership prejudicially, you could still be a partner in an ACCA firm so long as the majority are ACCA. This man lost his qualification. He could still have been a partner. No. Can you imagine carrying on with him as a partner? No way. Surety conduct is persistent breaches. Surety, well, you'll see it's a contrived word. It's contrived to fit into the notes. Persistent breaches, where one partner is part of the agreement is that they should prepare monthly partnership accounts, and he doesn't file returns with the tax authorities like he should do, like he was agreed. And he says, no, I'm not going, I can't be bothered, I'm too busy. Well, that's what you said last month and the month before and the month before. Persistent breaches of the partnership agreement. Well, go on then, do something about it. Go on, try and expel me. You can't, because I'm not voting in favour of my own expulsion. So they go to court and say, will you direct that the partnership shall be dissolved because of his fault? And the court probably would say, yes, we dissolve it. Now look at this. You've got here the mnemonic dissolutions, which is a clever little mnemonic, but you can see why I've got naughty and surety in there, because it wouldn't work otherwise. But we have a problem, because we've got 3 S's and we've got 2 O's and we've got 2 I's. So which goes where? Those are automatic. Those are by order of the court. And the automatic ones are things like matters of fact, whereas that is a matter of opinion. Unable to perform is a matter of opinion. Just and equitable is the court's opinion. Insanity is the court's opinion. Only able to carry on at a loss. You think we could continue making profits. Naughty conduct, naught. Define naughty. Come on. So these are matters of opinion, subjectivity. These are objective. And that's how you can remember. The last 6, the first 6, are all objective matters, all subjective matters. Quick word or two about LPA and LLPA. Limited Partnership Act and Limited Liability Partnership Act. Students often get these confused. And they're 2 completely different sets of legislation. Limited Partnerships Act, 1907, is over 100 years old. Still exists. At least one general partner who has unlimited liability. And one limited partner who only has limited liability. For this limited partner has limited liability. Must be registered with the registrar. The limited partner shall not take part in the management of the firm. He can look at the firm's books. He can give advice. He can give consultation. But he shall not take decisions. What's the difference between giving advice and taking part in management? Well, the answer is there's no need to take his advice. Only the general partners may take action and make decisions. If the limited partner does take part in management, then for the period that he is taking part in management, he shall become liable for the debts and liabilities incurred during that period. So better not to. The other characteristic of a limited partner is that they pay in a fixed certain sum by way of capital, and that's it. No more. If the firm goes bust, that partner loses that fixed contribution, but no more. So he's limited liability. If he takes any, let's say he puts in 15,000. If he takes out 5,000, so he's only got 10,000 left in the firm by way of capital contribution. When he takes that 5,000 out, he becomes liable in the event that the firm goes bust, dissolves. He becomes liable to put that 5,000 back in. but only that 5,000. So that's the most he can lose. If he doesn't take any out, that's the most he will lose. If he does take some out, that again is the most that he can lose. He shall not lose more than his fixed contribution. Limited liability is a relatively new feature. It's a 2000 thing, and it attempts to combine the better characteristics of limited liability companies together with the flexibility and relaxation of partnerships. It tries to combine the better elements of these two. And it came about because of high-profile accountancy failures. We started with the big six. I don't know if you know this, because it's the big four. We started with the big six. And then Coopers and Lybrand merged with Pricewaterhouse and became PricewaterhouseCoopers. So that comes down to the big five. And the Monopolies Commission said, no more. No more mergers of big accountancy firms. The big five shall never be the big four. And then Arthur Andersen went bust. And so it now became the big four. And that's a brief history of how we got to just four. I'm saying this because when Arthur Andersen went bust, as a result of the alleged, since proved not true, of the alleged shredding of important documents by a manager in Austin, Texas. Or was it Tucson? No, it was Austin, Texas. Partners in Arthur Andersen around the world lost out. Firms disappeared like lemmings going over the cliff in Norway. Clients just disappeared, and Arthur Andersen went into liquidation. Now, I don't know if any of them faced personal bankruptcy, but they could have done. But as a result of that, and then other firms also going into liquidation, it became apparent that people didn't want to be partners because suddenly they're at risk of losing the whole of their assets, all of their assets, the lot. So they want to ring fence, put a ring around their assets, the partner's personal assets. And they build this fence around, and it's called a ring fence. And as a result of dissolutions like these, it's become available now for partners to ring fence their personal assets so that they don't face personal disaster. There, the partners are not liable for the firm's debt. They protect themselves from personal disaster. Wrongful and fraudulent trading still apply, which we'll come to when we look at illegalities in company law. Combines the advantages of both, must be registered, and it must be audited. Now imagine that, because you've now got people like KPMG Audit, limited liability partnership, and that's had to be audited. Well, who audited? Somebody from Ernst Young. Well, who audits Ernst Young? Somebody from, who are the others? PwC. Well, who audits PwC one? Well, that would be done by KPMG. So the big four audit each other. I presume, I don't know. But that's how it works. Must be audited because it's now limited liability. But it protects the partners from personal liability, from personal disasters. That's limited liability partnerships. There are 13,744. When I checked just before I started this lecture, there are 13,744. No, there aren't. No, there aren't. That's checking for a company law thing. So that's the limited liability partnerships and limited partnerships. Don't confuse the two. Be careful. And I'm going to stop the lecture now, and then we'll finish up with partnership by looking at overseas type of business organizations that are similar to UK partnerships.